Good morning. It's Rob Ryder on August 28th, 2022. And today, Emergency Management Incident Report 22-141-128. My Staff Sergeant Robert Allen Rutluski, U.S. Army veteran, also known as Rob Ryder. And my email address is courtofrecord@aol.com. And so this video has to do with yesterday I called in 911 and reported an emergency. And the little fiasco that happened soon after that, and it wasn't that big a deal. But eventually I did get to put in an incident report, which was really the idea. And so now there is one. And this was kind of a continuation of my last couple of videos, which are on Rob Ryder on YouTube with 3 B's, ROBBBRYDER, which had to do with Avery, a supreme law of the land, and constitutional sheriff call 911 report the election emergency. And if you don't remember, didn't watch these before, well, in Avery, that's a Supreme Court case in 1968 where it was determined that when you have single members elected to represent a group of people, that those groups of people have to be by population, not by territory. So in other words, you can't necessarily send all the township supervisors to sit on a board to be the county board of supervisors, because not all townships are equally populated, which is how they had done it prior to that. Well, because of this, they had to change that and go to county commissioners who will sit on, make a county commissioner board, and each of those commissioners has a commissioner district that's based on population. Well, that's actually also your election precinct, because the county has become the local government. It's no longer the township. Right? So the county is acting as a municipality. And, you know, I can show you where Kent County says it's a municipality. So it's really not that difficult to grasp, right? That you can have county local government, or you can have county township local government. Now, that's what they say in Michigan. Your state's going to be similar, but at the end of the day, it's the county. The county's been divided into election districts or into commissioner districts, and each of those is a precinct. Well, that is the precinct that we're supposed to be, for myself, that I should be registered as a qualified elector of. But when you talk to the county, they have no idea what you're talking about. Okay, well then, constitutional sheriff, I had a chance to talk to a, quote unquote constitutional sheriff, who really isn't. He doesn't have a proper oath of office, but he could be if he did his paperwork right. And then I was hoping, well, why don't you guys call it in, sheriff? Why don't you call it into emergency management and put your other hat on, right? Because this isn't a local issue for the county. It's an emergency management issue, which is national. And that's what 911 is meant to be, is it's in the national emergency number. Well, I hadn't heard back from him, so, I finally said, well, I guess I'm going to just do it myself, and I'll wing it and see how it goes. And so I did, and so this video is going to be, what I said and what I did, so I can make my own public record of it. But, right now there is an incident report. And so what happens, I called 911, and I told them I wanted to read a little statement in, about a crime, and, was that going to be a problem? And she started to say something about, well, I should call somebody else. So I just started, reading it, because I wasn't going to let her say no. I'm going to go ahead and read the damn thing. And I didn't get all the way through it, and she hung up on me. I was like one paragraph from being done. I told her it's going to take 5 minutes to do, right? So I just started reading. I was trying to read it slow enough it would be clearly said, and blah blah blah, because sometimes I get amped up and slur my words a bit and all the other things that can happen. So she hung up on me and said, well, shit. So I called 911 back. I said, hey, you hung up on me. I wasn't done, reporting my emergency. And she said, well, you're quoting a bunch of laws and stuff. We don't have time for that. I said, this is an emergency phone number. But would you like to talk to a deputy? Or I actually said, well, what's your emergency? Is it police fire, or ambulance. Right? Those are the choices to give you. So I guess I said, well, it's police. And thinking later, well, it's not really police, it's emergency management. But she said, well, would you like a deputy to call you back? So I said, yes, please have a deputy call me. And she did, and 10 minutes later, a deputy called me, and I started to explain it to him. So, but what I got out of all that is that she didn't necessarily tell me that was my emergency an emergency management issue, which is different than police, because police is that's local. And so when I'm talking to this deputy, and said I'm trying to report an emergency, a crime of public officer impersonation. And the guy said, well, look, I don't think that any county prosecutor is going to prosecute something like that. They're worried about being sued. And I said, well, this really isn't for the county prosecutor anyways. This is, it's not a local issue. It's emergency management. I'm really trying to talk to emergency management or Homeland Security about this. And that's when he said, oh, okay. He said, well, there is a dispatcher for emergency management, but he's not here today. So I don't forget that I said this, because, they all came in little pieces in this conversation. But what he told me is that, if you have an emergency like this, you should call into the non-emergency number, right, and tell them you want to file an incident report for a crime, and then they're going to direct you, right? But when you're doing that, tell them it's an emergency management crime, right? Not necessarily a police issue. It's not local, it's national, right? Now, in England, and this would fall right in line with England. So in England, the sheriff had two different jurisdictions. He had a local jurisdiction, and he had the king's jurisdiction, or royal jurisdiction. And the things he had to do for the king were kept by the coroner, who was the keeper of the king's pleas. And the coroner was supposed to make sure that the king was taking care of that the sheriff was taking care of the king's business that he had in his list of things for the sheriff to do from the king. And otherwise, the sheriff was just working for the local jurisdiction, which is all the local thugs and robbers that call themselves the government. But they're really not. So, it's okay. Well, the sheriff can wear two hats, and I just need to take it to the other hat, which is emergency management. And when I will see if it is, because I did get an incident report. So, like I said, this video is really just for me to, make my report public. And so I'm going to read my report and what I wrote to him afterwards, and show the exhibits that I sent to him, and, we'll see where it goes. So give me just a second here. Alrighty, so I had this written up so I could just, read it as my statement on the 911, and so that's what I did. So I, Robert Allen Berlewski, U.S. Army veteran, DOD ID number 12112800006, need the next 5 minutes to record my emergency sworn statement identifying public officer imposters and their ongoing crimes against the United States. Please be patient. And that's when I asked the lady, so will you give me time to read this? And she said, well, you should probably call. She was talking about calling the Department of Justice. I swear, these crimes are a man-made disaster caused by individuals impersonating, falsely representing, or falsely acting as public officers who are terrorizing state inhabitants by offending the 4th Article of the Constitution of the United States Republican form of government guarantee, and are politically disenfranchising citizens of the United States in violation of the Equal Protection Clause of the 14th Amendment. Specifically, Gretchen Esther Whitmer did not qualify the office of Governor of Michigan. First, Whitmer avoided executing the oath required of all state officers that satisfies the 6th Article of the Constitution of the United States, as found in an act to regulate time and manner of administering certain oaths, signed into law by President Washington on 1 June 1789, commonly known as 1 Stat 23. Secondly, Whitmer filed a counterfeit of the oath required by the Constitution of Michigan of 1963. The counterfeit oath Whitmer filed is an improper oath It is not executed in Whitmer's full legal name, and it was administered by a person unqualified under Michigan law to administer the governor an oath. We'll look at all that stuff in just a minute. There is a vacancy in the offices of governor and commander-in-chief caused by Whitmer's failure to record constitutional oaths. Whitmer is not the governor. She's a public officer imposter, violating the Constitution of the United States, Section 217C of the Michigan Penal Code, and the Michigan Military Code of Justice, who uses a counterfeit of Michigan's Great Seal on acts of terrorism disguised as executive orders and other alleged official documents. The seal she uses does not conform to MCL, that would be Michigan Compiled Law 2.42, which describes the Great Seal. An investigation will prove Whitmer has many conspirators with the same constitutional oath defects who impersonate, falsely represent himself or herself as, or falsely act as public officer or public employee, and prepare, issue, serve, execute, or otherwise act to further the operation of the legal process or unauthorized process that affects or purports to affect persons or property. That's right out of the law. The same being a violation of MCL 752.17c. All right, Whitmer and her conspirators usurping as public officer are imposters who daily offend the United States Criminal Code's conspiracy to commit offense or to defraud the United States. That'd be 18 U.S.C. 371. Secondly, I and other county residents are politically disenfranchised by county officer imposters from registering as qualified elector in and from the county single-member election precinct we inhabit. This is a violation of the Constitution of the United States as interpreted by Supreme Court of the United States in Avery v. Midland County et al., case number 390, U.S. 474 from 1968. Michigan Election Law, Section 499, that would be MCL 168.499, requires qualified electors execute a Secretary of State approved elector registration application and swear under oath to its statements before the elector registration clerk. In my case, Kent County, Michigan is the local county municipality I reside in, making the Kent County clerk my registration clerk. However, that office's alleged incumbent is a public officer imposter who's unqualified to register me as a qualified elector of the county election precinct I reside in. Take notice that elector registration is a separate registration from voter registration. Elector registration under MCL 168.499 requires that an affidavit be administered and recorded, whereas no affidavit is required for a voter registration. Not registering electors in accordance with Michigan election law is an unconstitutional political disenfranchisement. This lack of proper election registration and usurpation of public office by imposters are man-made disasters requiring immediate relief. End of statement. I never got quite that far. I got about to right here where I said take notice, and that's when the phone hung up. But anyways, that was what I wanted to read into the record, and got most of it in on 911, got the rest of it in, or actually I didn't get it in. Then I talked to a deputy, and he gave me his email address, and I sent him some information, and he gave me a incident number, and hopefully it's going today to the emergency management dispatcher. So I may not have said this when I was first talking. So if you call the non-emergency number and you tell them you want to file an incident report, you're actually going to be talking to a dispatcher. Because when you call 911, all they're going to do is turn it over to a dispatcher. Right? And so in my case, it went to the sheriff dispatcher. But it doesn't mean it isn't an emergency management dispatcher also. Now, that's how I interpreted what the guy was telling me, and so we'll see what happens. See if I get a phone call today and follow up on this. So hang on a second. So anyways, I talked to the sheriff dispatcher for a bit, and he gave me an email address. He said, send your information here. This is the incident report, and the emergency management dispatcher isn't here today, but I'll get it to him for tomorrow. So I did, and so this is what I told him. Political disenfranchisement and other crimes against the United States, Emergency Management Homeland Security Incident Report, 22-141-128. Now, of course, he didn't say that's what it was, but I'm saying that's what it is. Right? I want to make perfectly clear this has nothing to do with local jurisdiction. Right? This is a national issue. So something I want to show is this is out of the state constitution for Michigan under local government section, where it talks about sheriff, right, security responsibility for acts. Right, so the sheriff may be required by law to renew his security periodically, and in default of giving such security, his office shall be vacant. The county shall never be responsible for his acts except the Board of Supervisors, which is now the county commissioners, may protect him against claims by prisoners for unintentional injuries received while in his custody. He shall not hold any other office except civil defense. And so as it turns out, what we call today emergency management is originally the civil defense system that was set up after World War II. I'm worried about nuclear bombs, all that kind of shit. You know, and it's a national jurisdiction. So when the sheriff puts that hat on, he's working for a different, or in a different jurisdiction than when he's acting as the county sheriff. And this has nothing to do with that, but because we're here. So we have this thing here called the Boards of Supervisors. And this is still in the Constitution today. Right, that the Board of Supervisors shall be established for each organized county, consisting of one member for each organized township, and such representation from cities as provided by law. Well, we don't do that anymore. Right now we have county commissioners. And this, little footnote here says constitutionality section, right, section 7, held invalid under federal constitution. Well, that would make the Michigan Constitution unconstitutional. If one part's wrong, the whole thing is wrong. And they've never changed it. And they have some reason for not changing it. But apparently that's not the way she works anymore, that now it's these county commissioners with the county acting as a local government instead of the townships acting as a local government. So, been quite a web they've weaved over time. But anyways, this is what I had to say to the deputy, right? So, deputy, thank you for your service and taking my call. I'm a U.S. Army veteran bound by oath to protect and defend the Constitution of the United States. And Incident Report 22-141-128 is my express will to fulfill my obligation, not do, to fulfill my obligation. FYI, for your information, all veterans are still in the United States military, as we have not received our administrative discharge order, releasing us from custody and control of our branch. I am sending you a few attachments that include the statement I read 911, check, done that, and various proofs to establish probable cause of crimes against the United States. This is a national civil defense emergency out of the jurisdiction of an alleged county prosecutor. For the sake of clarity, I am pasting a few sections of the Constitution of the United States referenced in the 911 statement into this email, which are, basically these. In Article 4, Section 4 says the United States shall guarantee to every state in this union a Republican form of government and shall protect each of them against invasion and an application of the legislature or executive against domestic violence. Well, we've been invaded, right, by esquires. Esquires are a crown agent by definition. Right, Article 6, Sections 2 and 3. So the Constitution and laws of the United States shall be made pursuant thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and judges in every state shall be bound thereby, and anything in the Constitution or laws of the state to the contrary notwithstanding. So, right, the Constitution is the supreme law of the land, and in Avery versus Midland County, the Supreme Court interpreted the Constitution to say that for equal protection of the law under the 14th Amendment to be valid, that we had to have equally proportioned election districts for the person that's going to represent us at the local level. And that isn't the way it was under townships, but that is the way it is under county commissioners. So, and the second part is that the senators and representatives before mentioned and members of several state legislatures and all ALL, all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification in any office or public trust under the United States. Now let me walk you through the probable cause of crimes against the United States. As is plainly written in Article 6, state legislatures, executive judicial officers of the state must execute an oath to support the Constitution of the United States. What it does not get talked about is that the very first act of Congress after ratification of the Constitution, signed into law by President Washington, mandates the form of oath and its recorded requirements. See 1 Stat 23. It's attached. And is also codified in the United States Code as 4 USC 101/102, also attached. So real quickly then, in the laws of the United States, right, Acts of the First Congress of the United States says that that the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the form following, to wit: I state your name, do solemnly swear or affirm, as the case may be, which is in there, that I will support the Constitution of the United States. Right? There's no "so help me God," there's no other stuff. Just I, your full legal name, do solemnly swear or affirm that I will support the Constitution of the United States, period. Well, that isn't the oath they're taking. Right? So now the Constitution says, well, you know, Article 6 is for state officers and officers of the United States. But they went further then, and they said, well, now we're going to put it in the U.S. Code, and we're going to say in Title 4, United States Code, Section 101, that every member of the state legislature and every executive and judicial officer of a state shall, before he proceeds to execute duties of his office, take an oath in the following form. Right? There's the same oath. And then such oath may be administered by any person who, by law of the state, is authorized to administer the oath of office, and the person so administering such oath shall cause a record or certificate thereof to be made in the same manner as by law of the state he is directed to record or certify the oath of office. Right? So until they have that, they don't have any authority. And that's where we stand today. They're not executing this oath. They're not recording this oath. And so they're not who they say they are. So then this mandate supersedes all other requirements for qualifying for the public office in Michigan, and federal law requires the incumbent have proof by record or certificate. If this oath is avoided by someone claiming to be a public officer, then that individual is an enemy of the United States, warring with the Constitution of the United States. Ignorance of the law is no excuse. And because we're talking about the Constitution and everybody has their opinion, you know, some people tell you there's 3 constitutions. Some people say there's a Constitution of 1871, there's a Constitution of 1776. This is the Constitution I'm talking about, the one in the 108th Congress, right, which says on it that it's the Constitution of the United States. Right? It's commonly called the Pocket Constitution, which you can Google Pocket Constitution, and there it is, Pocket Constitution. This is where it came from. Right, on govinfo.com or .org, .gov. Excuse me. All right, this is the one I'm talking about. Okay, just so we clear that up. Okay, so Gretchen Esther Whitmer is one such enemy of the United States. Not only did she avoid, I mean, she didn't do it, executing the national loyalty oath, but she also counterfeited the oath required by the Constitution of Michigan of 1963. I have attached her counterfeit state oath I received when I submitted a FOIA, Freedom of Information request, to the Michigan Secretary of State asking for all oaths filed by Whitmer. The national loyalty oath was not returned as part of the FOIA, and on the oath she submitted are the following invalidating indicators. The grammar of the oath text has been altered. Whitmer used an alias to conceal her full legal name, identification on the loyalty oath. A notary is unqualified by state law to administer an oath to the governor. And she is using a counterfeit of Michigan's Great Seal, upon which "the" is not part of the seal wording, nor is the capitalization used. MCL's 2.42. Let's take a look at that real quick. So here's what the Great Seal Act says in Michigan, right? That the Great Seal shall be comprised of coat of arms, state around which shall appear the words Great Seal of the State of Michigan, right? All letters are, or all words are lowercase except for Michigan. But when we look at what she did, or what she does, right, here's the seal that's being used, where the word the has been added, and it's all in uppercase. Well, then this is a counterfeit. It's really that simple. And, you know, in this particular case, this is the document that shut down Michigan for 2 years, right? Her Executive Order 2020-4, Declaration of State of Emergency. And then just real quick, if we look at the FOIA I did to get her information, right? Written request for image of the oaths of office subscribed by Gretchen Whitmer for the office of governor of the state of Michigan and its commander-in-chief. Right? Hey, we'll answer your question. And they sent me this. This is supposed to be oath of office, right? That, they changed the style of the words, right? Because Constitution of the state should all be lowercase. So the, grammatical change changed the meaning of the sentences. So it's not the same form, right? And Whitmer didn't use her full legal name, right? So she used an alias on a loyalty oath, which means it's invalid. And then it was, done before a notary public, who by Michigan compiled law 1536, 1537, I believe it's actually 1537, where it says who can give the governor an oath, and one of those people listed is not a notary public, which is who did it. Right? So this isn't an oath to satisfy the Constitution. It's a counterfeit to simulate satisfying the Constitution. Okay, continuing on. There's now a vacancy in the office of governor for failure to subscribe a constitutional oath. MCL, that'd be Michigan Compiled Law 168.66, which is out of the election code. Governor or lieutenant governor vacancy, creation, impeachment. Right? The office of governor or lieutenant governor shall become vacant upon the happening of any of the following events: death of the incumbent, his resignation, his removal from office for cause, his ceasing to be a resident of the state, his conviction of an infamous crime, or an offense involving the violation of his oath of office, the decision of a competent tribunal declaring his election void, or his neglect or refusal to take and subscribe to the constitutional oath of office and deposit the same in the manner within the time prescribed by law. Didn't happen. Office is vacant. Deputy, Michigan election law makes it your duty to initiate criminal proceedings. This is also out of the Michigan election law, talking about peace officers' duty to investigate proceedings. It's hereby made the duty of any police, sheriff, or other peace officer present and having knowledge of any violation of any of the provisions of this act to forthwith institute criminal proceedings for the punishment of such officer. I know what to tell you. Better be filling out the paperwork. It is not just Whitmer. No county officer, including the sheriff, has complied with the law to be a public officer they claim to be. No judge, justice, county commissioner, prosecutor, senator, representative, and is qualified incumbent of a public office. And this is why this is a national emergency. Michigan election law, again, MCL 168-191, county officers' eligibility requires all county candidates to be registered qualified electors of the county in which the election is sought. Why, sure enough, Michigan election law, a person is not eligible for the office of county clerk, county treasurer, register of deeds, prosecuting attorney, sheriff, drain commissioner, surveyor, or coroner if the person is not a registered and qualified elector of the county in which election is sought by the filing deadline. Right? And to be a registered, qualified elector of anything in Michigan requires you to take an elector's application that has an affidavit on it to the registration clerk so they can swear you to your statements. And nobody does that. Like I said, you can vote when you go and get your driver's license. Well, hey, here we go. Take notice. An elector registration is not a voter registration. According to MCL 168-499, in order to register as a qualified elector requires executing an elector registration application that contains an affidavit and appearing before the registration clerk to have the affidavit oath administered by the registration clerk and the application recorded. There is no such requirement for voter registration. And again, to the Michigan election law, where an elector entitled to registration in an election precinct may become registered in the precinct by applying in person and signing the registration application before the clerk or assistant clerk of the township, city, or village in which the precinct is located. For the performance of his or her duties under this act, each clerk and assistant clerk has the power to administer oaths and to swear persons as to the truth of their statement contained in the application. Nobody does that. Right? And this isn't something you do at the township, because the election precinct that I reside in now, because of Avery versus Midland County, is actually the commissioner's district. In my case, it's the 4th commissioner's district of Kent County, with Kent County acting as a city or a municipality instead of as a subdivision of the state. So if you investigated to determine that the county officers of 168-191 swore to the contents of an elector registration application, you will soon determine that they have not. This would include the county clerk, county treasurer, register of deeds, prosecuting attorney, sheriff, drain commissioner, surveyor, coroner. We have the same defect. It is part of the scheme run by Esquires to ensure that no inhabitant of the county is registered as a qualified elector of their county election precinct. I am sure you have never swore a registration application, and neither have I. This is intentional political disenfranchisement, a crime against the United States and we the people. The federal government has a duty under the 1965 Civil Rights Act to ensure we electors are properly registered, and the Supreme Court of the United States interpretation of the Constitution of the United States in its Avery versus Midland County decision requires the county commission districts are also our local government election precinct. Until I'm a registered qualified elector of my county election precinct, I am the victim of an ongoing crime against the United States of political disenfranchisement. Respectively submitted, blah, 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 blah. Okay, and so, what can be done? Well, one thing is, under the Emergency Management Act of the state, right, so every state's got an Emergency Management Act, I'm sure, right? It has certain things that the county can do. And in our case, in Michigan, it's under Section 410, powers of county and municipality. Right? Each county or municipality that has appointed an emergency management coordinator under Section 9 may do one of the following, or one or more of the following. Right? So as long as you're talking to the emergency management, that has a coordinator, then these apply. And one of them is, right, declare a local state of emergency. If circumstances within the county or municipality indicate that the occurrence of threat or widespread or severe damage, injury, or loss of life, property from natural or human-made causes exist, and under a declaration of this local state of emergency, issue directives and travel restrictions on county roads. This power shall be vested in the chief executive official of the county or municipality, or the official designated by charter, and shall not be continued or renewed for a period in excess of 7 days, except with the consent of the governing body of the county or municipality. The declaration of local state of emergency shall be promptly filed with the Emergency Management Division of the department under circumstances attended upon the disaster, prevent or impede its proper filing, or unless circumstances. Okay, so there you go. So if I could get them to do this, just go ahead and issue a local state of emergency, because there's nobody, in the civilian government that can issue an oath of office, because there is no civilian government. But the military can. And under Michigan law, there's people in the military that can issue an oath of office. Because military officers are not covered by the 6th Article of the Constitution. They're not an executive or judicial officer. They're a military officer. Now, up until they created the DOD, they were executive officers. But when they created the DOD, they said, hey, military officers are no longer executive officers. That falls on the head of the DOD, Secretary of the DOD. And so they're military officers. And these military officers and enlisted, we take a different oath than is required by the 6th Article. So there's nothing wrong with our oath. We're oath-bound protectors of the United States. And so emergency management, come on in, bring in, some military officers that can issue execute some oaths of office. And that's how you get everybody in their proper office, and we all get to be registered and da-da-da-da. But unless we declare it an emergency, they're going to, keep hiding it. But if it was declared an emergency, well, that would make it a national emergency. And I'm all about this being a national issue. This is not a local issue. And the only reason I'm going to the sheriff is because the sheriff wears 2 hats, right? He can be a member of civil defense, which is a national jurisdiction. Okay, I'm going to leave it there. I just wanted to make my public statement and put it on record. So you all have a great day, and I have more. I'll come back and tell you about it. Have a good day.